Well, trials are really only one of the options that we have for resolving cases. And also, it sometimes is the last ditch effort to try and amicably or positively resolve a case for a client. First goal would be to try and prevent our client from being charged with a crime at all. If a client meets with us during the course of an investigation, that's really our best opportunity to do as much damage control and evidence collection as we can. We run a concurrent investigation to that that's being conducted by law enforcement or by the Division of Child and Family Services. If we're able to successfully provide our version of events, sometimes that can result in no charges being filed at all. If someone is ultimately charged with the crime, depending on whether it's a misdemeanor or a felony, there are certain constitutional rights that are afforded to our clients in the court process. If it's a felony, then our clients have a right to have what's called a preliminary hearing, which is essentially a hearing where a judge would make a probable cause determination on whether or not the state or the government actually even has sufficient evidence to proceed to trial or to continue to prosecute our clients. If our client chooses to exercise their right to have a preliminary hearing, that affords us an opportunity to question witnesses, ask questions that we may think might shed light on a positive component of the case that we want the prosecutors to be aware of. We may want to preserve certain statements or certain bits of evidence before witnesses will forget or change their stories or change their minds. So having an opportunity to cross-examine witnesses is often an important part of our role as representation for our clients. Ultimately, our clients are the only ones who can choose to proceed to trial. Our clients have the option to enter into plea negotiations because they'd like to evaluate what their options are for resolving the case short of actually going to trial. Other times our clients do want to proceed to trial, to advise our clients on whether it's in their best interest to proceed to trial because we do think our best chance at beating the charges or obtaining an acquittal means going to trial. Other times, evidence may be overwhelming and proceeding to trial can be a very risky venture for our client and maybe result in a much worse outcome for our clients than trying to mitigate damage through plea negotiations. If our clients choose to proceed to trial, they have two options. They can proceed to trial in front of a judge, that's known as a bench trial, or they can opt to exercise their constitutional right to have a jury trial, which means that they would have a jury of their peers, 6 if it's a misdemeanor, 12 if it's a felony, actually hear the evidence. And in that case, all jurors would have the opportunity to evaluate all the evidence, listen to the witnesses, hear from law enforcement officers, hear from any other experts that may exist, whether that's lab technicians who've evaluated on toxicology or physical examinations or crime scene technicians. And at the end of hearing all that evidence, then a jury must be unanimous in determining that our client is guilty beyond a reasonable doubt. If they cannot reach a unanimous resolution and all agree that there is overwhelming evidence that shows no reasonable doubt as to whether or not a crime occurred, then they would find an individual guilty of that offense. But as far as preparing for trial, the experience that both Ashley and I have in having jury trials on sex crimes cases is vast. We've had the opportunity to try cases both as prosecutors and as defense attorneys on these types of crimes, which means that we are very qualified to engage in jury selection, engage in cross-examining witnesses on various types of evidence, on cross-examining lay witnesses, on questioning our own clients at trial, really preparing the best possible defense or defenses on our client's behalf. In preparing our clients for trial, many times that involves explaining the court process to them because it's a scary, unique process that many people never actually get to experience. The information that you glean from watching Law and Order on television or any other television show often gives a very skewed and unrealistic explanation or story about how a trial actually proceeds and what actually happens inside the courtroom. So adequately answering all of those questions, explaining the jury selection process, all of the possibilities of things that can happen during trial, objections that can be made with regards to evidence, how various arguments will be framed for a jury. Answering all those questions oftentimes puts our clients at ease about the fact that proceeding to trial is in fact in their best interests. Further, preparing our clients to testify is a very key part of our role as defense representation. Many people are very anxious, very nervous. They're not used to being questioned by lawyers in a courtroom. They know that they're going to essentially be on stage in front of a judge or jury that make very large determinations and decisions about the future of our clients as it pertains to whether or not they're innocent or guilty of a crime. So teaching them how to answer questions succinctly and directly to the point, not sounding as though they're making excuses, not being wishy-washy or being very direct and confident in their answers. So adequately preparing our clients to testify is important. Our clients also have a constitutional right to testify or not to testify. And if they choose not to testify, that can't be used against them. And so educating our clients on what the best course of action and what the best strategy may be at trial is something that's important for our clients so that they can make an educated decision about how they want to proceed and what direction they give for us on how they want us to help them resolve their legal matters.